Aloha and welcome to the Hawaii Assignment of Benefits Lunch and Learn webinar. My name is Ed Cross. Some people call me the Restoration Lawyer. I'm really grateful to all of you for being here today. We're going to talk about a subject that is near and dear to my heart, something I've been studying for a long time. There's a couple of people here that I have not met, and so it's great that you have logged on, and it's a pleasure to meet you. I wish we could be in person to do this. At the end of my presentation, I'm going to be telling you about an event that I will be presenting live in Honolulu next year, and I hope you'll be able to attend that. My practice is dedicated to the representation of restoration contractors. I've been doing it since 1997. I eat, live, breathe, walk and talk restoration. I'm all about it all the time. Done a lot of volunteer work in the area. And a couple of years ago, I was fortunate to be invited by the Restoration Industry Association to form an advocacy and government affairs committee to advocate for the rights of restoration contractors, primarily to get a fair claim in the insurance claims, a fair shake in the insurance claims settlement arena. And then the association actually retained me after that to serve as its restoration advocate. And in that role, what I do is I go to third-party administrators and consultants and many other stakeholders in the restoration ecosystem and advocate for positions taken by the Restoration Association. And if you're not yet a member of the Restoration Industry Association, I highly recommend that you join. The website is restorationindustry.org, and a membership in RIA pays for itself on day one because we have so many tools and resources there that you can use to help increase your bottom line and accelerate your receivables. On my private law practice side, I write lots and lots of contracts for restoration contractors. I enforce those contracts. In the prospect of enforcing them, I often find myself having to defend workmanship claims. So we deal with construction defect claims. We deal with indoor air quality issues as well. But the bottom line of most of it winds back to trying to get insurance companies to pay a fair amount for the work that's performed. And that's a big challenge that a lot of restorers face right now. So I'm going to share my screen. And what I have found in my practice is that the assignment of benefits is really the key to recovering fair market value for restoration services. There's many different ways that this comes true that I'm going to explain to you as we go through this. And as I've been practicing in this area, I find that restorers run into a number of problems kind of on an ongoing basis. There's some repeated problems that happen. And one of the big ones is a collections dilemma that exists in this industry. And a lot of restorers confront issues where third parties like insurance companies or third-party consultants or TPAs are trying to take control of the restorer's scope of work, or they are trying to control the price that the project is performed for. And recently, there's been a new movement by one of the insurance companies to start applying new construction pricing schemes to restoration. And so I have prepared the first draft of a position statement on behalf of the Restoration Industry Association addressing new construction pricing, which we believe often would not be applicable to restoration because it's so different from new construction. We see issues of third-party administrators withholding funds when work has been performed and when the restorer has actually earned the money, but it's being held by somebody else. We don't like when that happens. And so we see third-party interference with contracts. Like, for example, when the adjuster comes on and says, you know what, Mr. Policyholder, you should really use the competitor. You know, your restoration company charges too much or something like that. And if what the adjuster is doing is wrongful, like, for example, if the adjuster is saying something that's incorrect, that would give you potential legal rights against the insurance company or against an independent adjuster who's doing that. Not that you necessarily want to run to court and spend a bunch of money on a lawsuit. You probably don't, but the fact that you have the right to do that can give you some good leverage in negotiating arrangements with those people for them to stop doing that. And I'll sometimes write cease and desist letters to insurance companies saying, hey, wait a minute, you're getting involved, you're interfering with my client's business, you're doing it wrongfully, and you need to stop. So I think there's going to be a number of lawsuits filed in 2022 by restoration contractors against consultants, against insurance companies who are coming in and interfering with contracts. And that'll be one way that restorers can try to take back some of their control in all of this. So the other problem that we see a lot is that policyholders are not enforcing their rights under the terms of the policies to get the insurance company to pay fair market value. And restorers talk to me about this a lot. They say they're worried that the policyholder doesn't have the energy, doesn't have the money or the wherewithal to force the insurance company to pay the price that's correct. They're enjoying the benefits of your hard work. You've restored the property. They got a brand new house now. And gosh, I'm sorry you haven't been paid, but I need to go do something else right now. And they're not really coming to your rescue. And so an assignment of benefits is something that can help you in that regard. And then the most important part, probably of all of this, is that an assignment can help you prevent the situation where policyholders misappropriate insurance proceeds. The insurance check comes in and they use it to go on vacation, or they use it to pay off their mortgage. And this is a really big problem. We see this a lot. I'm sorry, I don't have any money to pay you, but I thought the insurance company gave you a check. Yeah, they did give me a check, but I don't have the money anymore. Well, that was supposed to be for us. Well, you need to secure the right for you to get that money, and an assignment is the way to go about doing that. So what are we going to talk about today? I'm going to tell you what an assignment is, what rights are assignable. We're going to talk about the right to insurance appraisals. I also think we're going to be seeing more of those because that's an inexpensive way to get these disputes resolved. And while I'm on the topic of expense for just a second, I want to talk to you about attorney's fees. And I run my practice in a way that's different from what some law firms do. You're going to hear me talk about the opportunities for you to reduce your legal expenses. And that may sound funny coming from a lawyer. What, charge less money from a lawyer? Yes, that's actually my goal. Not only do I think that's the right thing to do, but more importantly, we need to make sure that these issues get addressed on a larger scale. And if your lawyer bankrupts you with attorney's fees on a case, you're not going to be able to proceed with other matters in the future. My practice is built on long-term relationships with my clients. I have clients who've been with me for 20 years. And the object for me is for them to come back to me with future work. So I actually try to reduce the fees that I'm charging per case. I'm going to give you a few tips as to some ways that you can accomplish that as we go through. So I'm going to tell you a little bit about how to draft an assignment of benefits. We're going to talk about the presentation of assignments of benefits. We're going to talk about their enforceability. We're going to talk about insurance bad faith. I'm going to tell you about a reference guide that the RIA has put out. We're going to dispel some myths about assignments. and I'm going to talk to you about the Advocacy and Government Affairs Committee. So we got a lot of work to do, and I am going to end this at straight up 1 o'clock. So we're going to march through this stuff because your time is very valuable. An assignment is a transfer of legal ownership of something from one party to another. It's transferring title to something. So if you buy my car from me, I'm going to sign over title. You become the owner of that car. You can do the same thing with an insurance claim. And doctors do this all the time on when they're working for a patient who has medical insurance. When you go to the doctor, your doctor is going to have you sign an assignment. And everybody who's in this meeting today, who's ever had medical insurance, has signed many, many assignments of benefits, and you may not even know it. You're probably thinking, why do I even need to bother reading this fine print that the doctor has put in front? I need to sign, I need to be seen by this. I'm not going home now, right? So I'm going to go ahead and sign this. And what you're doing is you're giving the doctor the right to bill the insurance company directly. The doctor becomes the owner of the claim and the owner of the right to pursue a legal claim against the insurance company if they don't pay. Now, I see that as a convenience. I'd rather have the doctor chasing the insurance company for money than for me to have to do it. And for me, I just wait until my explanation of benefits comes through and it explains what my medical insurance company has paid. And you may notice they slashed the price. You know, the doctor charges $200 and they say, well, our price is $100 and then we pay $80 of that. My responsibility is $20 when it's all said and done. I just wait for that. It's a convenience. It's something that I appreciate. And the same thing is now starting to happen in the restoration industry. And an assignment is your ability to accomplish that. So you're taking ownership of the claim. And in the process, you're stepping into the shoes of the policyholder. And in that process, you're able to bill the insurance company directly, and you are able to get a front row seat for communications with the insurance company. And a lot of times my clients will tell me that they're concerned because the insurance companies stop communicating with them, particularly if there's been some sort of disagreement with respect to price. The adjuster will say, well, I'm done and I don't even need to talk to you. And arguably in some situations, they may even be right about that. But if you have an assignment, well, then you're the owner of the claim. And if they say, well, I'm just going to discuss this with the insured, then the contractor will say, well, I am the insured. And now let's talk about the fair market value for these services. Now, a lot of restoration contractors believe that they have an assignment of benefits in their contracts. And what I find much of the time is that they actually don't. What they have is a direction to pay. If your contract merely says that the insurance company is instructed to name you on the check, that's not actually an assignment of benefits, because that's just an administrative instruction. What we're looking for is something more like the example I gave with your car title. That's an official legal document that transfers ownership. So an assignment of benefits says that the policyholder is transferring all legal right, title, and ownership over the insurance claim to the restoration contractor. So we do not want to confuse a direction to pay with an assignment of insurance rights or an assignment of benefits. Those are two different animals. I put a direction to pay in my assignments as well. Maybe that's a belt and suspenders kind of approach, but still, that is what we need to do. And the problem is that a direction to pay does not create a legal relationship between you and the insurance company, whereas a legal assignment does. Some of the advantages of an assignment is that it gives you the ability to actually enforce the policy. Your policyholder customers may not be willing to enforce the policy, and an assignment will give you the right to do that and to challenge any underestimates or lowballs that are made by the insurance company in the process. We will be able to challenge misrepresentations of coverage, like we see these common emails, we do not cover overhead and profit. Well, tell me where it says in the policy that you do not cover overhead and profit. Guess what? It's not there. So they are not allowed to invent exclusions out of thin air. They need to pay the reasonable fair market value for your work based on the way the good, competent companies in your market are doing the work, the comparable companies. Small companies are going to have a different price range for services than the larger companies. If you look at some of the videos that we have on the Restoration Industry Association website, you'll see a video from Mike Fulton, who was interviewed, and he said that the reasonable value, the correct price for a job, depends on a lot of different factors. It's not necessarily the Xactimate price, okay? That came straight from the horse's mouth. It depends on the project. It depends on the access. It depends on the travel distance that you have. It depends on the particular needs of the customer. It depends on your particular needs as a company, what your overhead is, what your target margin is. It depends on what a willing buyer will pay a willing seller in your market for the services that are comparable to the level of service that you're providing. If you're providing a higher level of service than your competition, then you're entitled to a higher price for that. All right, we're not going to look at the price of a Chevrolet in Honolulu and say, okay, this is $35,000. Therefore, the price of cars in Honolulu is $35,000. No, the price of a Corvette is going to be higher than that. The price of an old Yugo is going to be a lot less than that. It depends on the quality of what's being provided. And there are fair market values for all of these different levels of quality. And we don't want them to pigeonhole us into just one particular price framework. And Mike Fulton has made clear that Xactimate prices are not intended to be global prices. It's not one size fits all pricing. So hopefully some of this is resonating with you guys. And, you know, these are issues that we're seeing on a regular basis. So if the insurance company is misrepresenting the nature of coverage or just saying, we don't pay for that, they're not allowed to do that. They're required to explain the factual and legal basis for any coverage decisions that they make. And so you can challenge any misrepresentations that they make regarding coverage if you are the owner of the claim. You can pursue damages claims against the insurance company if it delays the processing and the handling of the claim, if you're holding an assignment of insurance rights that's drafted in a broad fashion. You are also entitled in the great state of Hawaii to recover the attorney's fees that you incur in the process of pursuing a direct claim against the insurance company in certain circumstances. Some states don't allow that, but Hawaii does. Hawaii also allows for the assignment of punitive damages if the insurance company has done something really egregious with the mishandling of the claim. Then you can potentially be the owner of a punitive damages claim against them. Again, not because you want to file a lawsuit, you don't want to file a lawsuit, but having the leverage, having the right to file a lawsuit can give you a lot more power in those negotiations and hopefully reduce the number of incidents where you have to deal with these types of problems. So now let's talk about what can be assigned. You can, of course, assign the policy proceeds, which we call insurance benefits. But there's more to it than that. It's more than just an assignment of benefits. I think that we should look for assignments of other things, such as the right to go to appraisal. Appraisal is where the parties get together with an independent appraiser to set the amount of the loss. It's kind of like arbitration. You can get an assignment of legal claims against the carrier, such as claims for breach of the insurance policy. If they fail to pay according to the terms of the policy, you can become the owner of that claim and pursue it against the insurance company, as well as insurance bad faith, like I mentioned a little while ago. So because you've got these different kinds of rights beyond benefits that you can receive an assignment for, I'm no longer calling mine assignments of benefits. I'm calling them assignments of insurance rights, because we've got multiple rights under the policy. So this is kind of a new title. Insurance companies haven't really heard of an assignment of insurance rights. They've heard of assignments of benefits. And I want to get them to take a fresh look at this stuff. And so that's why I'm using this new title, and because it's broader than just an assignment of benefits. So it's an AOR, assignment of rights. And this will be a first impression for some of them. And in the process of getting this, you become the owner of the proceeds that are paid for your scope of work. You are not taking ownership of the entire claim. I want to make that very, very clear. Assignments are not very well understood, and the Restoration Industry Association and I are out to change that. And I want you to remember the doctor-patient analogy that I gave you a little bit earlier. And if you elect to proceed with an assignment and you get any resistance from people, you can just analogize to that. There was some bizarre stuff that happened down in the state of Florida. Don't judge assignments of benefits by what happened in the state of Florida. The courts down there were being unusually, extraordinarily liberal in handing out attorney's fees to contractors who were pursuing claims against insurance companies by way of an assignment of benefits. And it got kind of out of control, to the point there was a news report that said one lawyer filed 30,000 lawsuits in 1 year. I mean, I can't even get my head around. I don't know how many that is per day, but it's a lot. It's a real lot. That's not happening anywhere else. It's not happening in Florida anymore, for that matter, because they changed the law down there to prevent that from happening. The Restoration Industry Association has recognized the importance of this issue, and its Advocacy and Government Affairs Committee and I produced a reference guide, and it's the 50-state reference guide for assignments of benefits and insurance bad faith law. You want to be very, very familiar with Hawaii's claims handling regulations. You want to be go online and take a look at those Hawaii insurance claims handling regulations and see exactly what the adjusters are allowed to do, when they're required to respond, and what the requirements are for them. And if they violate those, chat with a lawyer about what the potential rights may be. So the association came up with this reference guide. It's a very extensive document, but it's not intended to be comprehensive. It's not intended to be legal advice. This presentation today is not intended to be legal advice. This is not a confidential environment. This is general information for you to use as a checklist when you discuss these issues with your lawyer. And so the association put out this compendium of material. And in the process, we read well over 500 cases and statutes. The law changes periodically, so you always want to check to see what the current law is. But this document is a great start. And in the introduction to it, it includes a few findings that lay the groundwork for this and explain the reason why the association took this on. The association found that significant losses occur when insurance companies delay claims, when they fail to properly investigate claims, when they wrongfully refuse coverage, when they fail to pay fair market value, and when they act in bad faith. That's pretty obvious. Well, the association found these problems to be a threat to the viability of reputable restoration companies like you, and that an enforceable assignment of insurance rights would fundamentally alter the dynamics of property insurance claims negotiations and settlements. A properly drafted assignment can be used to force the insurance company to pay a second time if the insurer was on notice of the assignment before the check was issued to the policyholder. Again, policyholder runs off with the money. You have rights. You can pursue claims both against the policyholder and against the insurance company when that happens. And the way we do that is I notify the insurance company that they've made a mistake. They paid the wrong party and they need to issue another check. What? Another check? You've got to be kidding me. Yes, another check. And I have accomplished this a number of times with a number of major insurance companies. I have forced them to pay a second time on a claim when they issued the check to the policyholder and did not put the restoration company's name on the check. Let's dig into the law of assignments a little bit. You know, assignments have been around for as long as there have been contracts. Assignments were addressed by the courts in England many hundreds of years ago. Assignments are enforceable in Hawaii and everywhere else. That's never the question. The question is, how do we handle the insurance policy provision that purports to prohibit assignments? And the way we do that is by emphasizing the fact that what we're getting is a post-loss assignment of the claim. Why does that make a difference? Well, what the courts say is that once a loss has occurred, there's a debt that's owed. The insurance company owes a debt to the policyholder, and that policyholder can transfer that debt to anybody the policyholder wants to. Why? Because that does not increase the risk of the insurance company. Insurance companies face risks when somebody attempts to transfer a policy. So if Rui were to transfer his homeowner's insurance policy to me, the insurance company would say, wait a second, Ed Cross is a much bigger risk than Rui is, so we're not going to agree to that. It changes their risk. Well, that's not what we're talking about here. With a post-loss assignment of rights under a claim, we are only assigning a claim, and that doesn't increase the insurance company's risk, and therefore the assignment is enforceable. So don't be dissuaded when somebody comes back and says, oh, well, we are supposed to give consent before there can be an assignment, and we do not consent to this, therefore the assignment is not enforceable. That is incorrect under the law of the state of Hawaii. So all policies have these consent provisions, and they'll say things like, for example, the policy cannot be assigned without our consent. Or it'll say the policy and the rights and benefits that arise from it cannot be assigned without our consent. But the law of the state of Hawaii says that these provisions that are in here are actually not enforceable once a loss has already occurred. So you can step into the shoes of the policyholder. The courts have ruled that these anti-assignment provisions violate public policy because they're a restraint on alienation. Alienation is the transfer of property between various parties. And the policy of American law and American commerce is to encourage alienation, to encourage the transfer of things between parties. Every time there's a merger and an acquisition, there's an assignment that's involved. And when I was paying off my law school student loan debt, about once a year, I would get a notice from the lender saying, okay, now we want you to make your payments to this other company. Why did that happen? Well, it's because they sold the note to that other company and they assigned the rights to collect that money over to the new company. And I just wrote my check to the new company, and it was no problem. There are a couple of insurance adjusters out there who say, oh, well, this will complicate things. It doesn't complicate things to write the name of a restoration contractor on a check. That it's not complicated. It's not difficult. They do it on mitigation checks all the time. So the courts do not want restrictions on the free flow of commerce. And the bottom line that you want to think about whenever you're looking at one of these is whether or not the assignment would increase the obligations of the insurer. It doesn't. So I'm going to talk to you for a second about appraisal. I think you should seriously consider getting involved in appraisals as an opportunity to reduce your potential attorney's fees and your collection costs. Insurance policies say that the parties can nominate appraisers to get together and set the amount of the loss in the interest of economy and efficiency. So you, as restoration contractors, are experts in pricing. You can serve as appraisers. You can get paid a consulting fee or an appraisal fee for doing that. You can also be a party to an appraisal if you take ownership of the policyholders' rights to go to appraisal. But basically what happens is it works like an arbitration. And you've got these two appraisers who come in, and if they cannot agree on the amount of the loss, they nominate an umpire. And presumably all of these people have some expertise in restoration pricing. And the umpire will set the final amount of the loss, and then it's done. That's binding. There's no lawsuit based on that, and it's done. So contractors work as appraisers, and there are three different ways that you can participate in appraisal. One is as a witness. So your policyholder customer is in a dispute with the insurance company and wants to come up with some sort of a resolution and wants you to come in just as a witness to testify about the work that you did. You can be the person who's actually an appraiser where you are rendering expert opinions as to what the amount of the loss should be. And then if you have an assignment, you can participate in appraisal as a party, but not if you don't have an assignment. Now, the next right that I told you about was the right to pursue claims for breach of the insurance contract and for insurance bad faith. What is insurance bad faith? Some people think it means, something evil or something malicious. No, all it means is that the insurance company is engaged in unreasonable claims handling practices. And there's all sorts of ways that insurance companies can be unreasonable, right? It does not mean bad faith in the ordinary sense, like evil intent. If there's some unreasonable failure to fulfill the duties under a policy, not just a failure, but an unreasonable failure, then that could be grounds for a claim for insurance bad faith. Well, why should I care, Uncle Ed? Well, Uncle Ed is going to tell you right now. You should care about insurance bad faith because if you hold the right to a bad faith claim, it gives you the ability to actually enforce the fair claims handling regulations. These are the rules that dictate the way the insurance company needs to process and handle a claim. You can also obtain the right to recover attorney's fees and punitive damages, like I mentioned before, and this will give you leverage in your settlement negotiations. Three basic categories of insurance bad faith. It happens in the processing of the claim, some unreasonable method of processing it, making you jump through too many hoops, or unreasonable paperwork requirements. It could occur in an instance where there's been some sort of misrepresentation, like we do not cover that, when in fact, the insurance company has covered that in the past, or some misrepresentation about the scope of coverage or the exclusions, or anything that just relates to general unfairness. I have a friend down the street who had a very unfortunate water loss in her house, and the insurance company is doing breathtakingly unfair things to my friend. It's horrible to see what's happening. The adjuster has gone to a couple of contractors, pressured them into slashing their estimates for the work, and then the price is so low that the contractors won't do the work, and the insurance company is saying, okay, you need to have this property completely restored because we're going to cut off your ALE on December 1st. Well, there aren't any contractors available to start this 5-week project until the middle of December. And so it's patently unfair what's happening there. And we really see it a lot. And so you're not going to get an assignment of that part of it, but you will see instances where claims are being handled in an unfair manner, and you can obtain rights to that. So you've got a right under a broad form assignment of insurance rights to pursue a claim against the insurance company for breach of contract. The insurance policy is a contract. They have obligations under it. They need to follow those. And the claims for breach of that contract are generally assignable. And I'm going to stop here for a second and see if you guys have any questions before we move into the next part of this, where I'm going to lay out the steps for you. And if you'd rather just put a question into the chat, you can do that, or I can unmute you now. Questions, comments, or complaints? Everybody's listening intently. So what we're going to talk about next is the steps in the process. Does somebody have a question? Okay, fair enough. Here we go. Here are the steps in the process. We're going to draft an assignment, obviously. And you're going to make a decision about what rights to include. I've outlined 3 potential rights. Specify those rights narrowly so that there isn't any confusion about what you're getting and what you're not getting. You don't want to try to get an assignment of the entire claim. That would include things such as the right to the value of total loss contents. That's not what this is for. You're not a public adjuster. You're not taking over the claim. You're just taking over the right to get payment for the part of the work that you did. I think your assignment of insurance rights should be irrevocable. And a lot of times, a policyholder, if they're going south on you, they may try to revoke it. And you don't want to have it irrevocable after you've been terminated from the project and you're no longer performing work there. If somebody else is going to come in and finish the job, they should be entitled to payment for that. But up to the point where your services end, you should have the right to pursue the rights under the policy. And it should be irrevocable for that time period, but it actually has to say that it's irrevocable. So you can include a direction to pay as well. And the assignment should say that you're receiving it as security. You're receiving it in consideration for your agreement to perform the work without the assurance of immediate payment. That's something that will help it to be enforceable. I also think that you should get an authorization from your customer to release information about the status of the claim, an instruction to the insurance company to give you a copy of the policy and the claims handling documents. And I do that with what I call an insurance information release and authorization form. It's a separate form I've dedicated just to this. It instructs the insurance carrier to release the policy, the claims correspondence, the adjuster estimates, the comp bids, and so on over to you. The insurance company might want to say, oh, we can't do that. It's private. So what I put into these authorizations is a waiver of the right of privacy as to these documents. And just like with the assignment, I make it irrevocable. So how do we present it? You present it to your customer, like I mentioned, as a matter of convenience and simplicity. This is a way to expedite the resolution of the insurance claim and to do it in an economical way. When you get to the point of execution, the best way to go about it is to simultaneously execute your contract, the assignment of rights, and the insurance information release and authorization all together. You want to give notice of the assignment promptly and politely to the insurance company. If you do not put the insurance company on notice of the assignment before the insurance company cuts a check, then the assignment is not binding on the insurance company as to that particular check. It's kind of a race to get the assignment to the insurance company as quickly as possible. I would not wait with that. When something goes wrong and the policyholder runs off with your money, then you will notify the insurance company that you will expect them to go ahead and pay. In other words, if they pay the wrong party, they're still going to have to pay you. If they pay the money to the policyholder, that does not discharge their obligations under the policy because those obligations are now owed to you. If the policyholder runs off with the money after the money has been assigned to you, you can pursue a civil claim against the policyholder for conversion. Conversion is the civil version of theft. It's a theft claim that you can make. And all you have to do is show that there's been a substantial interference with your ownership of the property without your consent, and that you suffered substantial damages in the process, and you can make a claim for punitive damages there as well. Punitive damages are designed to punish the wrongdoer. It's serving as a deterrent against future bad conduct. If someone has committed conversion, if your customer runs off with the policy proceeds after they've been assigned to you, and then they try to declare bankruptcy, you can probably prevent that debt from being discharged in bankruptcy because they have wrongfully taken your property, and the law of bankruptcy is not designed to protect people who steal things. That's not what it's for. So let's make sure we're not abusing assignments of insurance rights. They should not be used to inflate prices or to conceal the claim status from the policyholder. I really don't think anybody who's in this meeting today would engage in this, but I would be incomplete and remiss today if I didn't mention those points. You, of course, do not want to use an assignment of insurance rights to interfere with the policyholder's right to make policy or repair decisions. If they want to, fix their house in a certain way, an assignment doesn't interfere with that. We also don't want to use an assignment to interfere with the policyholder's right to terminate the restoration service contract where there's some good cause for that. We don't want to say, oh, well, you can't fire me because I own the claim. That would be a bad way to go about it. So there's some myths out there that a few people hold. We're dispelling these myths one by one. I told you that it's actually not prohibited by the policy. When you hold an assignment of benefits, you're not engaging in public adjusting. Public adjusting is when you represent someone else in a claim. When you own the claim, when you're the holder of an assignment, well, then you're speaking on your own behalf. You're not speaking on behalf of the policyholder. You're not adjusting. You are negotiating and just trying to get yourself paid. Assignments do not allow fraud. Nothing allows fraud. And the insurance company that's involved is only obligated to pay the reasonable fair market value for the work. That doesn't change when an assignment takes place. Assignments do not allow for price gouging, and they don't allow contractors to make their own repair decisions, and they do not require attorneys to pursue them. You can get a form and you can pursue it on your own. So here are some takeaways that I hope you got from this today. An assignment of insurance rights is a transfer of ownership of the insurance claim or a portion of it over to you. Please remember the doctor analogy that I gave. Remember that claims can be assigned. Consider the benefits of possibly going to appraisal. and also consider requesting an insurance information authorization and release form. Remember that just because you get an assignment of insurance rights doesn't mean you have to file a lawsuit. You present the claim just like your doctor does to the insurance company. Your doctor isn't filing lawsuits on that. Assignments of insurance rights do not require lawsuits. Remember to give prompt written notice so that you become the owner of any checks that get cut after the notice. Be persistent when you're pursuing these, and the squeaky wheel will get the grease. I hope you will join the Restoration Industry Association, and you'll get a free copy of that assignment reference guide that I told you about. There's a section in there that's dedicated specifically to Hawaii. So, an assignment of insurance rights may be right for you if adjusters are delaying, interfering with your scope and your price, or they're steering work away from you. An assignment may be right for you if your customers are not enforcing their rights under the insurance policy, or if they're running off with the money. An assignment of insurance rights may not be right for you if adjusters always treat you fairly. Or if the assignment of rights is prohibited by a contract that you have. You may be a franchise, or you may be under an agreement with a third-party administrator. There's certain types of assignments that those agreements may be prohibited, and you want to find out what types of assignments are prohibited there. And they're not usually very broad, the ones that I've looked at, but there's certain things that they don't want you to do, may not apply to anybody who's in this meeting today. If you'd like to have some forms for this, I have a set of forms and some instructions. I actually wrote a book on the assignment of benefits. And this is available at edcross.com/AOB. It's got the assignment forms in it. It has the notice of assignment cover letter in a downloadable form in Microsoft Word. You can put your name and logo on it, and you can use that to submit to the insurance companies. And it's also got the form, which is the insurance information authorization and release. It's got a section dedicated specifically to Hawaii law that lays out an approach that I've developed. And I put a little discount code up for you. The code is AOB100. You'll get $100 off. That expires tomorrow. If you'd like to check that out, have a look at edcross.com/AOB for more information on that. It's vitally important that the restoration industry unite. The industry is fragmented in some respects, and the best way to get together is through the Restoration Industry Association. And I hope that you'll make an investment in the Advocacy and Government Affairs Committee. There are dozens and dozens of hardworking volunteers working to make things better on everything from pricing to TPAs, third-party consultants. Many different issues are being addressed. So you can find out about that at restorationindustry.org. And I really hope that you guys will come out to the convention center in Honolulu for a big convention that's going to take place. The International Society of Indoor Air Quality and Climate, also known as ISIAC, is putting on a very special convention. It's called Healthy Buildings America. It's going to take place in Honolulu from January 18th to the 20th. And if you go on to isiac.org, you can register for that. I hope to see everybody there. This is a special event where scientists are going to be there collaborating with restoration contractors. You'll get the latest cutting edge scientific information from aerobiologists, from industrial hygienists, from mycologists, and learn about new technologies. I am a proud sponsor of the event and am going to be making a presentation there together with Dr. Ralph Moon, and that is entitled The Top 5 Mistakes Made by Restoration Contractors. So please go on to isiac.org, isiaq.org, and sign up for that. And I want to wish a hearty mahalo to all of you. And I'm going to open this up now to questions, comments, rude complaints, anything that, that you guys want to talk about on assignments or anything else. We have 8 minutes before your lunch hour is over. You can unmute yourself, or you can type in a question there if you'd prefer to remain anonymous, and I would be happy to answer that for you. May I ask, Kauai Restoration, what are your names?
I'm Casey.
Oh, Casey.
Tony.
Oh,
Casey,
hi.
Tony.
It's
Hi.
great to see you guys. I really appreciate you joining us today. Yeah, that's great. And Tanya, what company are you with? Are you there, Tanya? I see Tanya is logged on. She's unmuted now.
I'm with Premier Restoration.
Oh, terrific. Okay.
You over something, I sent, well, you were CC'd on it to help us.
Oh, right.
Yeah.
Okay. All right. It's all coming together now. So I think Shane, I don't know if Shane can hear me or not. I see that that Shane is logged on. I don't know if you guys all know each other, but I'm hoping there can be a way that Hawaii restoration contractors can get together. And Shane is now unmuted. Hello, Shane.
Hello, actually, Shane is not here. My name is Leilani Hollinger.
Oh, hi, Leilani. Oh,
Hello.
thank you for joining us today. So
Oh,
do you guys ever get together for coffee or lunch as a group, all the different restoration companies, and have a powwow, compare notes, and just talk about what's happening in the industry?
no, we don't. I'm relatively new to the industry.
Uh-huh.
And so I don't know if there's an association. Like, I am familiar with flooring associations, plumbers associations, but I don't know of a restoration association.
Yeah. So, you know, maybe what I'll do in January is maybe see if I could set up a room somewhere so the Hawaii restorers could get together. If I had the time, I would help you guys form like a Hawaii Restoration Association, because you're dealing with unique issues that aren't present in other parts of the country. And the members of the Restoration Industry Association nationally get a lot of benefit over hearing the strategies that each other has developed. And even though you're competitors, you can be cooperative competitors. Sometimes they call it co-opetition. And you know, there are a lot of issues that restoration contractors are really aligned on, even though they are competing with one another. And so it would be really good if we could, you know, get together for a couple hours somewhere, some way. And I don't know, maybe we'll do it at Brent's house. I think Brent raised his hand and volunteered to have it at his house. Thank you so much for that, Brent. That's terrific. So any questions you guys have on assignments or anything at all? We've got 4 minutes left here. Yes, Rui, tell me.
Okay, Ed, the question is like, you know, when do I present the post-loss assignment? As soon as step into the job, or as like, you know, as you have like the contract signed, or can be any time. And like, you know, I'm seeing that like my customers kind of skipping and not having the right answers from the insurance company. So yeah, your thoughts on it?
So you are presenting an assignment, and the policyholder has questions about the assignment. Is that what you're saying?
No. When should I present the assignment?
Oh, you should present
the assignment.
Got it. Yeah.
Job, or is it okay if like let's say we notice there's like a problem and the customer start complaining, look, my insurance is not helping. can that become later on the process, or?
Very good question, Rui. Thank you for asking that. So if you didn't get an assignment at the very beginning, which is my recommendation, but a problem arises later, you can get an assignment later. In fact, one of the insurance bad faith lawsuits that I'm litigating right now is one where we didn't get an assignment until long after the fact. And so that works where you are trying to get the insurance company to pay more money. And it's not that hard to sell your customer on this concept. And here's how I do it. I say, Madam Customer, we want to try to get your insurance company to pay. They have not paid the full amount for the work that was done at your house. We prefer not to collect from you. You signed our contract and you're responsible for it. But if you would assign to us the right to collect from the insurance company, we can expedite that process and hopefully we won't have to pursue collection efforts against you. If you're on reasonably friendly terms with the policyholder and they want you to get paid and they don't want you to come after them, then typically they will agree to that and they will sign that. But you know, it's best and cleanest, like I said before, to get the assignment signed simultaneously with the contract, just like your doctor has you sign the assignment before you ever go into the examination room. Any other questions? Anything at all? Insurance, contracts, policy rights, indoor air quality, world hunger? Okay, well, we are almost at the top of the hour. I want to wish a hearty mahalo to all of you. Thank you so much for being here today. And if I can ever be of any assistance to you, check out therestorationlawyer.com. And my number is 808-284-7545. It is 1 o'clock, and this is your Uncle Ed saying mahalo and aloha. Thank you.
Thank you.
Bye.
Bye, Tanya. See you later. Aloha.
Bye. Aloha.